Welcome to the Duty to Report module. This module is designed to guide engineers, geoscientists, and their firms through the critical professional and ethical responsibilities surrounding the reporting of conduct and behavior in their fields. By the conclusion of this module, you'll gain a clear understanding of what the duty to report entails, its importance, the mechanics of reporting, and when and how to take appropriate action. We'll also explore the potential consequences of both reporting and failing to report. This module is officially approved by Engineers Nova Scotia, Engineers Prince Edward Island, Professional Engineers and Geoscientists Newfoundland and Labrador, and Engineers and Geoscientists New Brunswick. This module is worth 1 PDH under the Ethics category. Duty to report. A legal, professional, or ethical obligation or expectation to report the conduct, activities, or behaviors, or professional practice of another person or group of persons in order to protect or prevent harm to the public or the environment. This duty is a fundamental responsibility of all engineering and geoscience registrants in Canada as part of their license to practice. Conduct or behavior may warrant a reporting if it is unethical, illegal, demonstrates a risk to the public. Whether on the job or outside of work, professionals may notice actions by other registrants that could potentially harm the public. These incidents may go unnoticed by regulators unless they're reported, which is why these reports are so important. In Atlantic Canada, engineering and geoscience regulatory bodies are legally obligated to protect the public. This includes safeguarding life, health, property, and the environment while ensuring trust in the technical and ethical abilities of their members. Maintaining this trust is critical, and reporting to the regulator plays a large role in that. Regulators have the authority or policies in place to require these reports to protect the public, ensure registrants uphold ethical standards, and maintain the profession's integrity. While the public can submit reports, they are not usually required to. However, employers, whether they are registrants or not, may have a legal duty to report professional misconduct by employees. They may also need to report actions like terminations or suspensions if those are due to unsafe or unethical behavior. Each regulator in Atlantic Canada has adopted their own code of ethics, which are similar to Engineers Canada's code of ethics, which was developed with regulators across the country. Reporting to the regulator is part of the ethical responsibilities outlined in the code of ethics by each regulator. A code of ethics serves as a framework to ensure responsible and ethical decision-making. Rather than being strict rules, these principles are meant to guide everyday decisions and actions. Duty to report can be either mandatory or permissive. All regulators in Atlantic Canada have mandatory reporting. A mandatory report means that a person is required by law to make a report. The purpose of reporting to the regulator is to help authorities identify and address risky or problematic behavior to protect the public. Engineering and geoscience are self-regulating professions, and our mission is, first and foremost, to protect the public. But regulators cannot deal with problems that are unknown to them. It is therefore crucial to identify and report unethical, illegal, dangerous, or unlicensed practice to your regulator or relevant authority. In doing so, you are protecting the public, the environment, and the reputation of all professional engineers and geoscientists. Registrants are therefore legally required to report another registrant if they have reasonable grounds to believe that the person is practicing engineering or geoscience in a way that could cause serious harm to public health, safety, or the environment. Here are 2 examples of situations which shall be reported to the regulator. A structural engineer discovers that a colleague has approved building plans without conducting proper load calculations. A geoscientist learns that a fellow registrant has falsified environmental impact data for a mining project. In some situations, employers are required by law to report actions like termination, suspension, or leave taken against a professional due to unsafe or unethical behavior. For example, a firm suspends an engineer for repeatedly ignoring safety protocols in a chemical plant design. A company terminates a geoscientist for manipulating soil test results to favor a client's development plans. Similarly, professionals may need to self-report if they're involved in criminal, civil, or regulatory matters. For example, when an engineer is charged with driving under the influence and must report this to the regulator. When a geoscientist declares bankruptcy and is required to inform the regulatory body due to potential financial conflicts of interest. There's also a broader expectation for registered professionals to report concerns about colleagues engaging in unsafe or unethical practices. Regulators' codes of ethics require professionals to report unethical, illegal, or unsafe behavior to the relevant authorities. Ethical obligations typically include holding paramount the health, safety, and welfare of the public and have regard for the environment, acting with integrity, honesty, fairness, and objectivity in their professional activities, and upholding and enhancing the honor, dignity, and reputation of the professions. In addition to ethical reporting obligations, some jurisdictions have laws that require professionals to report certain matters to their regulators, including criminal or civil proceedings. Since laws vary by region and can change, it's important to understand these general principles and stay updated on your specific regulator's rules. Regulators have a legal responsibility to protect the public interest, and reporting to the regulator is part of fulfilling that duty. This includes ensuring that registrants practice engineering and geoscience safely, ethically, and professionally while guarding against risks to the public safety, health, the environment, property, economic interests, and overall welfare. It's important to note that the risk must come from a registrant's failure to meet the standards of practice in engineering or geoscience, not from the inherent risks in certain fields. For example, mining carries controlled risks to the environment. If a mining engineer follows the standards of practice and keeps the risk within acceptable limits, no regulatory action is needed. But if the engineer fails to meet these standards and the risk goes beyond acceptable levels, the regulator may need to act. Risk management is a key part of these professions, and it's understood that projects often involve some level of risk. However, this risk must be kept within acceptable limits following the standards of practice. Risk analysis enables risk assessment, which in turn enables risk management. Engineers and geoscientists analyze risk for probability and consequences so they can assess risk with respect to acceptability in comparison with societal and industrial thresholds for acceptance, so they can ultimately manage risk. In the assessment phase of the risk management process, engineers use risk management standards and guidelines. The steps involved are as follows. 1. Planned review, gather data. 2. Identification of hazards using qualitative and quantitative risk assessment techniques. 3. Risk analysis, assessment, measuring the probability of risk and the consequence of and severity of risk. 4. Is the risk acceptable? This is determined using a matrix. 5. Manage the residual risk with safety management systems. 6. Can the risk be reduced? 7. reduce the risk. 8. If risk reduction is not possible, discontinue the activity regardless of personal or professional consequences. Protecting the public interest also includes maintaining public confidence in the professionalism and integrity of engineers and geoscientists. Engineers Canada's public guideline on risk management offers useful advice on how to identify risks and keep them at acceptable levels. If a registrant fails to meet these standards and the risk exceeds the accepted level, regulators may need to step in to protect the public. Regulators are primarily concerned with crimes involving moral turpitude, which refers to actions that go against community standards of justice, honesty, or good morals. If a registrant is charged with or found guilty of such crimes, it raises concerns about their good character, a requirement for all registrants. Crimes of moral turpitude include fraud, arson, robbery, assault, kidnapping, and aiding or abetting criminal acts. A more detailed list can be found in Engineers Canada's Guideline on Good Character. The public trusts that engineers and geoscientists have the technical and ethical competence to serve society and have the willingness to put the public interest first. As the public may lack specialized engineering knowledge, they typically form opinions about engineers and geoscientists based on interpretation of character and the quality of engineering and geoscience practices. Good character includes qualities like integrity, honesty, and trustworthiness, which are essential for professional practice. Individual engineers and geoscientists must demonstrate good character in addition to adhering to their jurisdiction's code of ethics in order to maintain trust and with it the right of self-regulation. Demonstration of good character includes, among other aspects, conduct within a professional capacity and may also include personal conduct. The engineering and geoscience professions understand that public trust is carefully conferred and must be protected. Trust is fragile and easily lost. In the best interest of the public, regulators therefore seek to ensure 1. That all applicants are of good character before admitting them, and 2. That all registrants maintain their good character and uphold the reputation of the professions. In order to assess the character of applicants, regulators may employ such tools as character references, character-related questions on application forms, requirement of applicants to pass a professional practice examination which covers law and ethics, and/or criminal background checks. Assessment of character can be subjective, so it is important to consider information from several sources when making an evaluation. A negative finding in any one area does not mean that the applicant will be denied, but that more investigation may be necessary. Engineers Canada lists 5 main categories of good character. 1. Trustworthiness. Reliable, doesn't lie, cheat, or steal. 2. Respect. Treats others with dignity. 3. Responsibility. Understands the consequences of their own actions and doesn't blame others. 3. Fairness. Treats others with empathy. 5. Integrity. Makes ethical choices and has the courage to do what is right. Examples of professionals who do not display good character would include an engineer consistently uses offensive language in professional communications with clients and colleagues. A geoscientist repeatedly misses project deadlines and fails to communicate with team members, affecting the firm's reputation. A civil case is a private case where someone sues someone else. This is also known as a suit or action. In a criminal case, the Crown prosecutes an accused under a public law statute such as the Criminal Code or the Controlled Drugs and Substances Act. Civil lawsuits, such as malpractice cases, can raise concerns about a registrant's competence, safety, and ethics in their practice. Additionally, like with criminal cases, civil proceedings can also raise concerns about a registrant's good character, even if it is not directly related to their practice. For example, lawsuits involving human rights violations, such as discrimination based on race, gender, or religion, can question a registrant's character. More details on discrimination and protected grounds can be found in Engineers Canada's Guideline on Good Character. Examples of civil cases that would be relevant to professional conduct. A homeowner sues an engineer for negligence in designing a retaining wall that collapsed during a heavy rainfall. A mining company files a lawsuit against a geoscientist for providing inaccurate mineral resource estimates, leading to significant financial losses. Unlike criminal cases, registrants are usually not required to report civil proceedings when they start. Reporting is typically only required or encouraged after the proceedings conclude and findings are made. If findings are made, the regulator may take action. However, evidence from civil cases is generally protected by the implied undertaking rule, meaning it cannot be used outside the case without court approval. Therefore, evidence from a civil case cannot be submitted to a regulator without permission from the court. Any registrant who is involved in civil actions and is found liable is advised to report the finding directly to the regulator. Registrants may work in multiple Canadian jurisdictions and even in other countries, such as the United States. If a regulator in one jurisdiction investigates or finds professional misconduct or questions a registrant's fitness to practice, this concern is relevant to regulators in other jurisdictions where the registrant also works. Investigations or findings from other regulatory bodies can raise questions about a registrant's competence, safety, ethics, or character. For example, an investigation by a privacy commissioner regarding a breach of client information, an investigation by an environmental regulator about damage caused by a project the registrant was involved in, an investigation by a municipality for building code violations related to the registrant's project. The reporting requirement for such investigations vary by jurisdiction. Registrants might need to report when an investigation begins or when findings are made. It's important to remember that an investigation does not automatically mean professional misconduct. If reporting is required at the investigation stage, it's good practice to provide updates on the outcome as well. In some cases, a criminal conviction may be considered professional misconduct. Registrants may be required or encouraged to self-report or report others who are convicted. Reporting rules differ by jurisdiction and may apply either when proceedings start or after a conviction. Competence means having the right knowledge, skills, and judgment to provide the engineering and/or geoscience services you're responsible for. Registrants should only take on work in areas where they have the necessary training and experience. Examples of incompetence in engineering or geoscience include failing to properly supervise work, taking on tasks outside of your training, expertise, or scope of practice, not following rules for using the professional seal. Here are some more specific examples you might encounter. An electrical engineer with no experience in aerospace systems accepts a contract to design avionics for a new aircraft. A geoscientist trained in petroleum geology provides expert testimony on groundwater contamination without proper hydrogeology experience. Each regulator has a code of ethics outlining expectations for ethical behavior. Following these practices is key to maintaining public trust in the integrity of engineers and geoscientists. Here are some examples of unethical or unprofessional conduct. Providing engineering or geoscience services while hiding a conflict of interest. Engaging in inappropriate behavior like sexual harassment, discrimination, or bullying. Billing dishonestly or submitting false or misleading invoices for services. In Canada, fitness to practice means having the physical and mental health needed to provide safe, competent, and ethical services. A registrant is considered unfit to practice if 1. They have a medical, physical, or mental condition, and 2. Their condition either A. prevents them from performing their professional duties entirely, or B. affects their ability to work safely and competently, warranting conditions or limitations on their license. A registrant is not automatically deemed unfit simply due to a condition. If they understand their condition's impact and manage it appropriately to ensure competent and safe practice, they are generally considered fit. Issues of incapacity arise when a registrant lacks insight into how their condition affects their practice or refuses to acknowledge it. In such cases, reporting to the regulator might be needed to address potential risks to the public. Conditions that could lead to a finding of incapacity include substance abuse or addiction, cognitive issues and mental health issues, physical health problems. Some real-life examples. An engineer develops a substance addiction disease affecting their ability to apply engineering principles. They are unwilling to seek treatment. A geoscientist begins to experience cognitive decline, which affects their ability to produce clear and accurate reports. They're unaware of the root cause and attribute any issues raised by colleagues to technical problems. Reporting fitness issues can be complex, involving legal and ethical considerations. In jurisdiction where reporting is required or encouraged, there are usually specific legislative requirements and guidance for managing these matters. In some jurisdictions, registrants must self-report to their regulator if they are involved in criminal, civil, or regulatory investigations or proceedings elsewhere. Regulators might also request self-reports through policy, which could occur either shortly after an event or during registration or annual renewal, depending on the situation. Individual registrants must report concerns about other registrants if there is a significant risk to the public interest, including both tangible risks, such as safety or health, and intangible risks like the profession's integrity. A mandatory reporting requirement is based on a reasonableness standard. This means that a report is warranted if there is a reasonable belief of a risk to the public interest. Example, an engineer discovers that a colleague has been using an outdated building code, potentially compromising structural integrity. Many codes of ethics require reporting not only misconduct by registrants, but also any actions that may put the public at risk, even if the person involved isn't a registered professional. The right authority for reporting depends on the situation. Environmental risks go to environmental agencies, while fraud should be reported to law enforcement. Registrants should seek advice on how and when to report non-registrants. Reports should be made when there is a reasonable belief that public safety may be at risk, even if certainty is not achieved. Examples of reporting non-registrants: ignoring a professional recommendation in a way that threatens public safety, unlicensed individuals practicing engineering or geoscience. Unlicensed practice is illegal and can pose serious risks to the public. Unethical or risky behavior by other licensed professionals, such as architects or lawyers, that you may have dealings with, should be reported to their own regulators. Registrants should assess if the conduct poses a public risk and follow these steps. 1. Warn the employer or client. 2. If unresolved, escalate to the regulator, relevant government department, or appropriate authority. 3. Avoid legal agreements that conflict with reporting. Any person who has a concern about the competence or professionalism of an individual licensed engineer or geoscientist, or a company holding a permit to practice or certificate of authorization should first discuss this concern with their regulator. The regulator can provide more information on the allegation, complaint process, and determine whether the matter falls under its regulatory authority. Next steps. 1. Direct communication. It may be appropriate to discuss concerns directly with the registrant or individual whose conduct is in question. This approach can sometimes resolve misunderstandings and may avoid unnecessary reporting. 2. Employer or client. Some regulators require or expect that concerns be raised with the employer or client before making a formal report. This is known as the duty to inform. According to Engineers Canada's recommendations, if an employer or client intends to override a decision that risks public safety, the registrant should explain the risks and their duty to protect the public. If the issue is not resolved, a report should then be made to the regulator. When not to notify directly. If there's a chance that the concern is based on a misunderstanding, talking directly with the impacted party might clarify the situation and prevent unnecessary reports. If there's a risk of retaliation or safety concerns, it may be safer to proceed directly with a regulatory report without direct communication. If the registrant is bound by confidentiality agreements and has learned about the issue through legal proceedings, this may complicate the reporting process. In such cases, seeking legal advice to understand the impact of these obligations on the reporting process is crucial. It is important to note that all reports are considered confidential. The regulator will not make information about the registrant's conduct public knowledge unless the discipline committee orders that its findings be published after the completion of a formal hearing. Individual registrants are usually responsible for reporting to the regulator. The general public can report issues, but they're not legally obligated to, except for employers or related entities who might have specific reporting duties. 1. Reporting concerns about other registrants. What to report? If you suspect another registrant or licensed professional is acting incompetently or unethically, you can report this to their regulatory body. How it works. This reporting process may be separate from a formal complaint, meaning you might not be involved in any investigation or notified of its outcome. Regulatory bodies should provide clear instructions for reporting concerns. If no distinct reporting process exists, reports are typically managed through the complaints process. 2. Reporting to additional authorities. When to consider concurrent reporting. For issues that may involve broader risks, such as environmental hazards, report to the Ministry of the Environment or appropriate environmental authorities. Why concurrent reporting matters. Certain issues may require attention beyond the regulatory body to ensure public safety and compliance with laws. 3. Reporting unlicensed practice non-registrants. What to report. If you observe someone practicing without a required license, such as performing engineering work without proper credentials, report this to the relevant regulatory body. Guidance on reporting unlicensed activity. If you're uncertain where to report, consider seeking legal advice. For example, if a land surveyor or architect is providing engineering services, you may need to report them to both the engineering regulator and their specific regulatory authority. Do not use media or social media as a substitute for formal reporting. Ensure public statements adhere to professional standards and avoid risks of defamation. Social media does not offer the same protections as formal reporting. Often legislation or policy will specify what needs to be included in a report. Reports should typically include a clear, chronological, and concise summary of the events or facts that led to the concern about public risk. Details if a report has been made to another relevant authority. The names and contact details of individuals who can provide more information related to the concern. Copies of all relevant documentary evidence supporting the allegation. To be most effective, reports should be made immediately upon becoming aware of a conduct or behavior that is unethical, illegal, or demonstrates a risk to the public. This allows regulators and other authorities to address potential risks to the public promptly. Delays can complicate investigations and increase risks. After a report is submitted, the regulator will decide the next steps, which usually involve investigating the alleged conduct. The nature of the investigation and any subsequent actions will depend on the specifics of the case. Here are some potential outcomes. Disciplinary proceedings. If the regulator finds reasonable grounds for professional misconduct, disciplinary actions may be pursued. Independent medical examinations. If there are concerns about a registrant's capacity to practice, they might be referred for a medical examination. Enforcement action. If an individual or entity is found to be practicing without a license, enforcement actions may be taken. If the regulator determines that the conduct does not pose a risk to the public or is outside their jurisdiction, no further action will be taken. In such cases, the regulator might refer the matter to the appropriate authority. When reports are made to other bodies, like law enforcement or government departments, the outcomes will depend on their jurisdiction and power. Reporting to the regulator is both a professional and ethical duty for all registrants. Reports should be made in good faith and not used to harm others due to personal or professional conflicts. Although some may feel hesitant to report concerns due to camaraderie or loyalty to colleagues, failing to report when required can breach the codes of ethics and, in some cases, legal obligations. Consequences of not reporting. Failing to make a required report may be considered a violation of the codes of ethics and, depending on the jurisdiction, could also be against the law. Not reporting when mandated can lead to disciplinary action against the registrant. In some cases, individuals harmed by the conduct might sue the registrant for not reporting. Reporting should be based on a reasonable belief of risk to the public, not personal vendettas. Even if the exact risk is uncertain, if a reasonable person would think there's a potential risk, it's appropriate to make a report. If you face retaliatory actions after reporting, like from an employer, you should report this retaliatory conduct to the same regulatory body, department, or agency where the initial report was made. If a registrant retaliates, they may face disciplinary action for professional misconduct. Some provincial statutes offer whistleblower protections for employees who report unsafe or illegal conduct. These protections prevent adverse actions against reporters if the report was made in good faith. Retaliatory actions could result in fines or other penalties. While it doesn't prevent retaliation, whistleblower insurance can provide financial support for legal costs, loss of employment, and expenses related to finding new work. For example, Engineers Canada offers whistleblowing coverage as part of its secondary professional liability coverage. This insurance is automatic for engineers and geoscientists in Atlantic Canada and covers a broad range of individuals. You may be covered in other ways. For example, Competition Bureau Canada offers whistleblower protections for individuals reporting bid rigging and price fixing, and the Public Service Disclosure Protection Act protects employees in the public sector. Overall, these protections are designed to support and safeguard reporters who act in good faith. The complaints process begins when a written allegation is received against a registrant. A complaints committee investigates and considers the matter. Following the decision of the complaints committee, you may request a review of the decision. This review is restricted to determining whether or not proper procedure was followed in arriving at the decision. You may be asked to further participate in the investigation or act as a witness if the regulator decides disciplinary proceedings are needed. If disciplinary proceedings are initiated, the reported registrant has the right to a full and fair hearing. This includes receiving full disclosure of the information and evidence used against them, allowing them to respond to the allegations. Similarly, if someone is prosecuted for unlicensed practice, they are entitled to access relevant documents and information as per the court's rules in that jurisdiction. Remember that regulatory reporting is a key professional and ethical responsibility. While we've covered general guidelines and best practices, it's crucial to stay informed about the specific requirements in your region. Your role in making these reports is essential in helping regulators and other agencies uphold public safety and trust. Thank you for your commitment to maintaining the integrity of your profession.